Our guest this morning is Major Anna Beier-Pedrazzi, and Major Beier-Pedrazzi has been a member of the Air Force JAG Corps since late 2011. She is an alumni of my own alma mater, Claremont McKenna College, which is very exciting. So way to rep, Anna. Thank you for being here. And she's also a graduate of the UC Davis School of Law, and she received her LLM in Air and Space Law from McGill University just last year. So very, very excited for Anna to be here. Again, as I've said, she has been a JAG since late 2011, has served in a variety of base legal offices, has also served as an area defense counsel. She is deployed to Al Udeid Air Base in Qatar, and has also had a variety of other jobs in the JAG Corps before her current position, which is as a space law attorney in the JAG Corps' Operations and International Law Directorate's Space Law Office. So Anna, with all of that, welcome. Thank you so much for being here, and I will go ahead and turn it over to you. Thank you.
Jeremy, thank you very much for that very warm welcome. And thank you also to the Law, Technology, and Warfare Research Cell for graciously hosting me in this talk today. I wanted to give one brief disclaimer that although I am a major in the United States Air Force, and although the Air Force did send me to McGill as part of an AFRIT-sponsored program, I am appearing here today in my personal capacity, and all the opinions and conclusions or otherwise that I'll be discussing are solely my own and not to be construed as any official position of the United States Air Force, the DoD, or any other US government entity. In fact, I have specifically removed my uniform blouse to remove any rank, name, or other military appearing endorsements so that we're all clear. Okay, so with the legal disclaimer aside, many thanks again, Jeremy, for the warm welcome. Let's go ahead and get started. So what I will be presenting today is the topic of my research thesis that I did at McGill University last year. I'm excited. I will actually be walking for the graduation ceremony next week in Canada. So that'll be a really neat opportunity as well. But I will be talking to you all today about some of the legal issues with the military's use of commercial space transportation. When I looked at this topic originally, a lot of you, when you hear this topic, you might think of lots of different contexts. I looked at a very narrow use of the military's use of commercial space transportation. And what I mean by that is I limited my research and analysis specifically to people and cargo. So in this presentation, I won't really be talking about, the United States military's contracting for example, to launch satellites or things like that. There's quite a bit of research on that topic as well, but that's not what I focused on. So now that we know kind of the parameters of what we'll be discussing today, let's get into the meat of things. Okay, so as any good legal advisor will do is before we get into the legal analysis, we need to kind of set up the facts. So that's what I'm going to do in the first part of the hour, is talk to you a little bit about what are the facts, what's driving these requirements, why is the military interested, both historically and now, why is the military interested in using commercial space transportation to potentially transport personnel and cargo via spacelift. And then secondly, I'll be delving into, so as far as the legal issues go, I'll be delving into a few different topics. So first, I'll talk about regarding suborbital flight. So for flights that do not reach a full orbit, the difference under the Chicago Convention between state aircraft and civil aircraft, and where this kind of suborbital transportation, if contracted by the military, sort of falls in like a legal ambiguity zone. Then second, I'll be talking about the Civil Air Reserve Fleet as a potential model to utilize spacelift as a surge capacity for the United States military, whether or not that's feasible, whether or not it's recommendable, etc. Then I'll talk about really just in my thesis, I covered a number of different domestic issues, but for today's talk, I'll just really be focusing on one. And then lastly, I want to talk to you all a little bit about some of the issues of the law of war and of applying and of using commercial space technology during armed conflict. So without further ado, let's lay down some facts. So as many of you may already know, during the Cold War, there were really only two players in town. That was the USSR and the United States, who were the pioneers, if you will, of exploration of outer space, and also the two players driving technological advances in space technology. The Cold War era was marked by a significant this tension between cooperation to prevent nuclear war on one hand, but competition to assert one's status all around, diplomatically, militarily, economically on the other. During this period of initial space exploration, the state, and really just two, as we talked about, is the primary actor in space. One political historian by the name of Walter McDougall has described the state in this era of competition as the dominant promoter and manager of technological progress. So it's really the government that's driving a lot of this technological innovation and development, et cetera. But that's not the case anymore. Today, we have lots of actors in space. And although a lot of our nation's strategic documents identify this new era as one of strategic competition among the United States, China, and Russia, it's not like they're the only three players in the space game. Commercial entities have become significantly more prevalent since the Cold War, and especially in the last 15 years. The number of actors in space is really expanding exponentially. And unsurprisingly, when you have this many actors in space, the legal regime that was originally designed during a period where there were only two parties really acting in space, and both of those parties were state parties, is not really perfectly designed to encapsulate all the new issues we have today in the space domain. Unsurprisingly, law evolves slower than technology. And really the goal of my thesis was to identify where we need to develop law, or where are going to be the stumbling blocks. If the United States military truly does want to use commercial space transportation to transport personnel and cargo, is the legal regime ready for that? Where are the gaps? Another person I like to quote for you for a minute is Professor Daniel Goudouy, who was the world's first chair of air and space law, and that was at Leiden University. And he puts this in context. When you think about how much slower the law develops behind technology, he talks about how many centuries it took for the principle of freedom of the high seas to develop for law of the sea, versus how fast the Outer Space Treaty regime developed relative to the launch of the first satellite. So although technology is accelerating, and although law comparatively is accelerating, it's just not accelerating at a rate that can keep pace with technology. We need to look at, where does the law need to catch up? So with that as kind of an introductory background of what was the goal of my thesis and where are we going, let's talk about some of these facts. So the US military has been considering the possibility of space transportation for personnel and for cargo since the Cold War. And this isn't surprising, because when you have this tension between these two superpowers, the drive to come up with new and better ways to outdo your rival is present. So when I was thinking about what topic should I write my thesis about, I thought about the last several years I've been in Air Mobility Command for 4 years prior to attending McGill. And it really came to have an appreciation of just how amazing logistics, particularly like transportation by airlift is. When I was the legal advisor several years ago to the 621st Contingency Response Wing, we learned all about palletizing and how that unit does its mission to get up and transport cargo anywhere in the world within a very short time frame. And then in the expedition, when I was at the Expeditionary Center, I got kind of a higher level look at some of this agile employment, this agile basing concept that we are moving towards in the military. And so when I was thinking about what topics should I look at, air mobility was very much in my mind because I had just come from AMC. So getting back to kind of historical, what's driving the need for the military to look at this as an option? You can kind of trace that back to the Berlin blockade and the subsequent airlift that took place between 1949 and 1950. That was really one of the most clear examples of where transportation via aircraft had a strategic impact on US priorities at the time, and where the United States, what the United States needed technologically to overcome military logistics hurdles. So that was the first real demonstration during the Cold War of the significance of transportation via airlift. And then about a decade later, in August 1961, we had the Berlin crisis when East German police and military units shut off sealed routes to West Berlin. We had the Berlin Wall being built. And at that time, the United States really recognized that airlift is going to be the strategic option of choice, because land and sea routes are not going to be available in the event of a crisis in Europe, particularly and possibly likely starting from Berlin. So as a result of the building of the Berlin Wall in 1963, the United States had a massive exercise in conjunction with NATO partners called Operation Big Lift. And that was a wargaming scenario in which the United States simulated attack by the Warsaw Pact against East Germany. This was a feat of logistical brilliance. This was truly a show of what the United States could do in terms of airlift in a very short amount of time. In total, the U.S. in Operation Big Lift, the United States transported 14,500 troops and 500 tons of cargo in 235 sorties across a 5,600-mile route between the airfields of Texas and Europe. So that was a really important moment in U.S. airlift logistics history, because it demonstrated what air could do in times of crises that land and sea could not do. And so when the United States is thinking about how can we maximize options from the air, space started to come into the picture as something to consider for the future. After Operation Big Lift, Douglas Aircraft Company became interested in this idea and conducted some studies in which they looked at ways to overcome limitations that aircraft had, because although aircraft enabled the United States military to do things that other options could not, aircraft still have limitations. For example, in order to have a successful airlift, you need to have all the infrastructure required for aircraft, such as runways, air traffic control, certain weather is a constraining factor. You need fueling facilities, all these kinds of things that are still limiting factors when responding to a crisis. Winston Churchill said in 1949, rather famously, that strange as it may seem, the Air Force, except when it's actually in the air, is the least mobile of all the services. A squadron can reach its destination in a few hours, but its establishment, depots, fuel, spare parts, and workshops take many weeks and even months to develop. So there are still limitations to airlift and air power that Douglas Aircraft Company was looking to potentially at least overcome some of those. So when they were doing research, they came up with this concept that you can see in this very mid-century modern picture on the side. It was called Icarus, perhaps aptly named, but later renamed Ithacus, that would have, if it had come to fruition, it would have been able to deliver 500,000 pounds of payload to any point in the world within 45 minutes of launch. Now, you might be like, okay, I don't know what that means in practical terms. Like, what does that give the United States military? One example that gives this a more tangible feel, especially when you're comparing it to what Operation Big Lift did, is that it enables 1,200 fully loaded troops to go anywhere in the world in under an hour, excuse me. So that's kind of been some of the historical development and the interest in the US military on this issue. There have been a couple of other concepts, and I'll talk very briefly about some recent developments that if any of you are interested in what the US Air Force is doing in this realm, you can go look up after if that's something you want to be more informed on. So in the same way that every strategic era produces some options. Oh, one note as to why this never came to fruition. Basically, the DoD concluded it's too expensive. The cost per pound of cargo is just too much, given the technology at the time. But as you can see in the slide, the rise of commercial space has led to decreasing launch costs. And that's why this concept has become attractive and has become salient yet again as a concept as a concept of employment for the United States military. There are tons of these types of studies and examples throughout the decades. That's way beyond the scope of what our presentation is, but I'll just talk about a couple more, and then we'll turn to the law. In the early 2000s being marked by, of course, the pivotal 9/11 terrorist attacks, we entered into the war on terror, and so insertion into access into areas with difficulty access, particularly of soft troops, became a priority for the United States military. So in 2002, the US military began working on space transportation options to support combat operations as part of the war on terror. One concept or two closely related programs that the United States military was exploring at the time was some cooperation and the possibility of suborbital and also orbital transportation for the US Air Force and the US Marine Corps. One of those programs was called the Small Unit Space Transportation and Insertion Program, or SUSTAIN, and that would have been able to insert unmanned aerial vehicles into any area of the world within 2 hours. The companion initiative to SUSTAIN was the Operations Tempo Energetic Access to Globe and Launch Experiment. That's a mouthful, which is known as Hot Eagle. And that was an effort by DARPA to investigate spacecraft options to fulfill the SUSTAIN mission. So that was kind of a couple of efforts during the war on terror. Now, as I mentioned in the intro, we're in an era of strategic competition where, again, we need to look at different, where this is again becoming a salient topic. And so in June 2021, the United States Air Force announced its 4th Vanguard program as part of its transformational technology portfolio. And that 4th Vanguard is called Rocket Cargo. Under this new vanguard, the Air Force Research Laboratory is looking into the possibility of using commercial rocket technology to rapidly transport military materiel and potentially troops across the globe. The idea behind this program, or the goal, or what strategic limitations it's trying to overcome, are pretty similar to that of, the Berlin days, which is that the stated objective of this program is to demonstrate new trajectories and ways to fly large rockets and the ability to land rockets in austere locations and design and test an ejectable pod for airdrop. This kind of technology lends itself also very well to humanitarian missions. So I'm going to play a brief clip. If you go to AFRL's website, you can see what they're doing. But this is a clip without sound, so I'll keep talking as we go through. So this is being considered for mainly humanitarian purposes. Interestingly, very similar to what I did when I was the legal advisor at the 621 CRW, which was deployed a number of times in response to humanitarian crises such as in Haiti, also to Puerto Rico as a result of the hurricane. So the program, what AFRL is doing is awarding contracts to different companies to explore what is possible. So one of the companies that is working under this program, or that they have a CRADA with, or research agreement. I should clarify, not contracts, but these are essentially collaborative research agreements. They're known as CRADAs. Is SpaceX, to look at different options for cargo bay designs, landing, etc. And there's also a CRADA with Blue Origin and with another company, I believe that's called XARC. So just this gives you an idea of what the military is trying to accomplish today using this transportation technology as a potential option in its transportation and / logistics network. So with that, let's turn to some law. So as I mentioned at the beginning, one of the things that I looked into and which is still an issue of legal ambiguity is, well, let's back up a second. So as I mentioned, the current space legal regime was not designed for this kind of paradigm. And many of the limitations we see in the law are a result of the law coming out of an era where two states were the main actors in space. So one of the things I looked at was this ambiguity of civil versus state aircraft under the Chicago Convention. So just so we're clear, and just so no one thinks I'm blurring any lines, the Chicago Convention deals with aviation. However, there have been some proposals by various scholars that possibly the International Civil Aviation Organization could play possibly a regulatory role in suborbital transportation in the future. That's not a topic I explored in my thesis. There's a lot of other scholarship on that already, but the idea of if that were to come to fruition, or if suborbital flights are in some way being regulated by the ICAO, there is this ambiguity under aviation law, under the Chicago Convention, about state versus civil aircraft. Jeremy, as I'm sure you know from your studies, there's this long-standing debate about how to classify, a spacecraft, whether, should you go with the functional approach? In other words, what is this thing designed to do? Because now we have these space planes that, for some part of their trajectory, operate more like planes, but in other parts operate more like a spacecraft. So what is it they're trying to do versus a spatial designation, which just kind of sets a ceiling at, okay, if you're flying above a certain point, then you're a spacecraft. So that's a long-standing debate. I didn't get into that too much, but these are issues as far as if we are going to have And right now, suborbital kind of commercial spaceflight is really limited to the ultra wealthy at the moment. But if this technology becomes ever cheaper and proliferates, if there is eventually, let's say, a commercial tourism industry for this kind of suborbital flight, it's not unreasonable to believe that the ICAO would become involved in regulating this industry. So when we're talking about the difference between civil and commercial aircraft, this has a long-standing history going back to the Paris Convention and then eventually into, as I mentioned, the Chicago Convention. So to make a long story short, as far as the Chicago Convention is concerned, the Chicago Convention does have a certain amount of ambiguity and really leaves it up to contracting states to determine whether an aircraft is civil or whether it's state. There are special protections for civil aircraft. For example, under Article 3 bis of the Chicago Convention, the shoot down of civil aircraft is specifically prohibited. However, there have been a number of incidences, which I covered in my thesis, about when aircraft have either been intercepted or in fact shot down, and whether or not this aircraft was a state aircraft or a civil aircraft. The ICAO also did a study on whether or not it could be definitively determined and what factors there were between a civil and a state aircraft. And ultimately, the ICAO study that was from the early 90s, 1993, I believe, that that study explored different factors to be considered in the classification of aircraft, and ultimately concluded it's not definitively possible to do so. The other difference is that in determining why this is important of this ambiguity between civil and state aircraft, if it were to pertain to the military, so the military would be a state entity, but the commercial space transportation provider is a commercial entity. When you have this kind of combination, if you were applying the Chicago Convention, it wouldn't be perfectly clear if eventually, like I said, the ICAO gets into the business of regulating some of these suborbital space flights, it wouldn't be entirely clear what the status of that aircraft is potentially. Now, to be clear, the United States does, for purposes of domestic aviation law, the United States does designate aircraft as either civil or state. However, that may differ with another country's interpretation of what that aircraft is, which has implications for what level of protections it gets under the Chicago Convention, and also, frankly, what overflight requirements are, what overflight privileges are required to be requested prior to that flight. Basically, civil aircraft can overfly versus state aircraft require permissions. So, as I said, if a civil aircraft were to overfly, it is protected. But if a state aircraft were to overfly without permissions, it doesn't have that Article 3 bis protection. So really, this is an unresolved area of law, and one that regulators, if commercial suborbital transportation really does become more prolific, where the average tourist could potentially afford a flight on such a spacecraft, and the military were to contract such transportation, it would be somewhat unclear under the Chicago Convention whether or not this spacecraft that may fall, at least for some period of time, under the provisions of air law. Again, that's currently not the case, but could be under a future regulatory regime. It's not clear that all countries would have the same understanding of whether or not that suborbital spacecraft that spacecraft conducting a suborbital flight is in fact state or civil. All right, the next thing I want to talk about is the Civil Air Reserve Fleet. This has been something that's been brought up a number of times. Different parties have said, you know, it's time for a craft for space. There are some initiatives looking into this, etc. I came to a more conservative conclusion in my thesis about whether or not we should really be looking into this for the purposes of commercial space transportation. Oh, one note I wanted to clarify on my last topic. I really on the last point of analysis focused on suborbital flights in the as a potential area that might come in the future under some of the legal regimes of the Chicago Convention, or could at least theoretically in the future if that were determined to be the case. That's not what rocket cargo is aimed at. These are really like heavy rockets. This is not that program is not for suborbital, but I looked at this problem of or this issue of the military's use of commercial space transportation holistically, and I didn't just limit it to current initiatives like rocket cargo, just for clarification on the technology itself. Okay, let's turn to craft for a minute. So a little bit of context for the craft. So President Harry Truman created the craft by executive order in 1951. Unsurprisingly, and this goes back to our previous discussion about the facts underpinning the law, the establishment of craft followed the Berlin airlift of 1948 to 49. And what is underpinning the craft is the Defense Production Act of 1950. So what the craft is essentially authorized under the authority issued by Title I of the Defense Production Act. Title I is the, presidential authority to require the performance under contracts or orders that the president has deemed necessary or appropriate to promote national defense. So really, in a way, it's the president saying, hey, private actors, you must perform these items because the US has a need for this capability during a time potentially of national crisis that would promote the national defense. So Title I also empowers the president to allocate things like materials, services, and facilities that the president deems necessary to promote national defense. Okay, so that's the legal construct for the craft. So what we have to remember is that craft is essentially a surge capability. So as part of the craft, you have craft being a voluntary model whereby airlines currently participate, but it can be then called up during this time of national crisis to promote the national defense. US Transcom is already considering integrating space transportation as part of the military's capabilities under the craft model. But again, we have to remember this is a surge capacity. So if we were going to include spacecraft into the program, a lot of the US code would have to be updated to include, right now the code is written that it pertains to aircraft allocated or identified for allocation to the Department of Defense under Section 101 of the Defense Production Act. So obviously some of the code would have to be rewritten and updated to include air and spacecraft. The other thing that we have to remember is that craft is essentially a surge capability. So when we think about the craft, these private entities are only activated or only come into service when it's determined that what the military has as organic capability are insufficient. But that's not really the reality we have right now with spacecraft. It's not like unlike where, we have in our inventory, we have cargo plane, we have C5, C-17s, et cetera. That's part of our organic capability. But when we need to surge, we have the availability to do so through commercial airline surge capabilities provided by a number of different airlines. We don't have the same construct right now with spacecraft and spacelift. It's not like the United States Air Force has in its arsenal a ton of the equivalent of C5 and C-17s as spacelift organically. Right now, the premise is that we are contracting for these services under normal conditions. So if you're contracting, AKA you don't really have organic spacelift in the same way that you have organic airlift capabilities, it seems, essentially my conclusion was, it seems a little silly to be talking about, at least for the purposes of cargo and personnel, it would seem a little superfluous to get into, should we consider a craft model? Because craft's a surge capability, but we don't have anything organically. So anything we need is going to have to be contracted. Why I suspect at least this is attractive to the private sector is because there could be certain indemnification provisions that might be attractive to the private sector that are available through this kind of arrangement that would not be potentially available through regular contracts. But really, it's not, from a government point of view, it's not really necessary to put this in a craft model. The craft is a surge capability, and when organic capability is insufficient. But right now we don't have an organic capability. So the answer, at least as far as what I concluded, was just do normal contracts. This whole thing about the craft is just really unnecessary at this point for transport. If troops and cargo were to become contracted through the military, or excuse me, if the military were to contract, for these services, there's a reason that private insurance exists, because space launch is still a very risky activity, and the government really doesn't want to be on the hook for that. So through normal contracts with commercial entities that are required as part of their licensing provisions to have private insurance, that model is just fine. There's no need to bring in the CRAF and the Defense Production Act. In other words, there's no need to use the might of the president to get commercial space companies to do these things for us. Often the government is the primary customer anyway. So we don't need to use this sort of coercive or emergency power of the president to get them to do what they're very happy to do for us on a day-to-day basis. Okay, so next, I want to talk to you. I looked in my thesis at a number of different things, but I just want to talk about one thing specifically for time, and also just for complication factors. And that is really, if the US military were to truly contract for space transportation services of personnel, in other words, that US military members would eventually become passengers in a spacecraft, what kind of domestic legal issues does this raise? And the one I came across is the fact that under domestic law, not unsurprisingly, recognizes space launch as still a very dangerous, risky activity. So in looking at domestic launch law, just to give some definitions, launch is defined as to place or to try to place a launch vehicle or re-entry vehicle in outer space, or otherwise, in Earth orbit in outer space or otherwise in outer space. In general, the Secretary of Transportation can waive requirements, including the requirement to obtain a license if certain conditions are met. However, the requirement to obtain a license is not waivable if human beings are on board. So different conditions must be met depending on whether the space vehicle will transport crew and also flight participants. A flight participant is not the same as the crew. A spaceflight participant is an individual who is not crew or not a government astronaut carried within a launch vehicle or reentry vehicle. So when you think about some of the millionaire suborbital flights of a few years ago, I think about a year and a half ago or so, they would not have been astronauts. The FAA, in fact, changed the law to say that those folks that were just mere passengers on board were not astronauts. They were just flight participants. So one of the issues, if the military were to do this, is the fact that if you're taking a flight participant on board, the license holder has to inform the flight participant in writing about the risks of launch and reentry, including the safety record of the launch and the reentry vehicle type. So this is like you are on notice as a flight participant that this is a risky endeavor. That doesn't really lend itself to a rapid response capability for troop transport as the technology exists currently and as the law exists currently. So until spaceflight is to a level of safety, reliability, and really proliferated, in other words, it's not, the purview of only millionaires who can afford these kind of things. This is really going to be a big barrier if the U.S. military ever wanted to seriously consider, and the technology is not there yet. I'm not trying to say that the U.S. military is ready to put airmen or soldiers or Marines onto spacelift tomorrow. That's not what I'm saying at all. But if this were to be something the U.S. military wanted to explore or whatnot from a technology point of view, that would be something that would need to be looked at in terms of the domestic system. I suspect that as launch becomes more reliable and more safe, the requirement to have in writing informed of your passengers that this is a risky endeavor will go away. Okay, that's about enough on that. Let's briefly talk about some of the issues of law of armed conflict. And Jeremy, as you know, there are a number of efforts right now to kind of come up with the equivalent of a Tallinn manual for space. When I wrote my thesis on this, I think that in the middle of my research, McGill put out Millamos towards the end of my research period, and I think Woomera is also either close to a final version as well. So when I was writing on a lot of these issues, there have been a number of scholarly articles on this topic, but kind of a manual of the equivalent of, let's say, Tallinn was not yet out. Those endeavors are still out there. And I imagine that the kind of stuff that I looked at will continue to be a salient scholarly topic going forward, because we have this we have the issue of applying law of armed conflict in a domain that wasn't really contemplated when the rules of the road for armed conflict were contemplated. So I'll talk briefly about a few issues. There are loads more. Like I said, there are entire scholarly endeavors dedicated to coming up with manuals on this. I'll just talk about a very few issues. So one of the issues that we have is deciding which is the lex specialis during armed conflict. You have the Outer Space Treaty regime that applies, period, regardless of armed conflict. It applies in peacetime, and certainly it's not suspended during wartime. But when there is a conflict of laws between the Outer Space Treaty regime and other agreements and the law of armed conflict, which one is the one to follow? And many people might say, well, it's armed conflict, so clearly the laws of armed conflict or laws of war should apply. But it's not quite so clear because it depends on whom you're talking about and what the situation, because in some scenarios, it might make more sense for the Outer Space Treaty regime to continue to govern as the preferable treaty regime. But in many other circumstances, it may make more sense for the law of war to apply. I use law of armed conflict, law of war interchangeably. The DoD has generally preferred law of war in recent years, but I think you all know what I mean in any case. So one of the things is, for example, the provision of the rescue agreement that requires the return and the render of aid to astronauts. And so that really gets back to, again, this idea of like who's an astronaut versus who's a mere flight participant, versus, for example, there is not necessarily the same, duty to rescue your combatant. We have certain rules as far as how we can deal with combatants, but there's not quite the same duty to rescue under the law of war. This is also kind of similar. The rescue agreement is also similar to the Chicago Convention's requirement under Article 25 to render assistance to aircraft in distress. And a similar requirement is also under maritime law as well, to rescue under the Salvage Convention to rescue crew and passengers who have gone overboard. So that's just one. Again, there were many examples I looked at in my thesis, but that's just one example of where it's not quite clear which laws do we apply, which do we suspend, and what is the status of those passengers. Do they fall under what under outer space law should be a person that requires rescuing or not? Then some other issues under the law of armed conflict as applied to space, and then I'll end here shortly so that we have some time for questions. But I do want to cover a few more topics under the law of armed conflict. So the law of war and customary under treaty law and under customary law regulate war regardless of where it is conducted, and that would include outer space. Also under the Outer Space Treaty, there is the direct application of the UN Charter to outer space. So clearly law of war doesn't apply in space. One issue when we're looking at the different rules of the law of war, necessity, proportionality, distinction, humanity, the two that I kind of focused on were the proportionality and distinction issues. And we can kind of see this in a little bit the Ukraine conflict with the provision of Starlink internet services to Ukraine. So the last thing I want to talk about is this idea of distinction. If you have an object that is dual use, what applies for the purposes of the intersection of the Outer Space Treaty and the law of war? The first way you kind of have to look at this is a two-part test, which is based on Article 52.2 of Additional Protocol 1, in which the US generally recognizes as customary international law. The first part of the test is whether an object by its nature, location, purpose, or use makes an effective contribution to military action. And so you have to look at what is the nature of the use of this object. So even if this is a commercial spacecraft, if it's being used by the military for for purposes of conducting hostilities, you get there. The second part of the test examines whether the total or partial destruction, capture, or neutralization in the circumstances ruling at the time offers a definite military advantage. So again, this would have to be very fact specific as far as, you know, what the status of that spacecraft is, what is being used for, and whether or not targeting it would produce a military advantage. But you can see where this dual use nature of civilian spacecraft becomes problematic. The last thing I want to talk about is like distinction, or excuse me, is proportionality, sorry. When you have engagement in space, if you were to have kinetic engagement, you have this problem of orbital debris, which then triggers issues of liability. So let's say you were to have two states in an armed conflict engaging in kinetic attacks against each other's space objects. What about the third-party liability to neutral states who are not engaged in this armed conflict? Under the Liability Convention, there is fault liability for damage to space objects in outer space. So if the two warring parties are creating orbital debris that is harming third parties, you would have, for example, under the Outer Space Treaty also, and then as elaborated by the Liability Convention, you would have potential liability issues as part of a conflict. But it's not really clear, because typically in armed conflict, when things get broken, it's not like you're generally, usually it's to the victor goes the spoils, and generally it's not really determined on a treaty-based fault-based provisions how liability would shake out. So with that, I am at kind of close to the hour. Thank you all for your time and attention. I look forward to what space technology will yield in the future, and how the military will continue to look at creative avenues for using space technology, particularly as this kind of technology becomes less expensive and more viable as an option in the U.S. military's in the U.S. military's logistics network. So thank you all for your time and attention. And with that, I'll turn it over back to you, Jeremy, for questions.
Great. Thank you so much, Anna. We do have a question from one of our anonymous attendees. This question reads, Major Beier-Pedrazzi, wonderful presentation. Thank you. Do you think commercial launch providers will be hesitant to coordinate the transport of military assets or personnel during an armed conflict if they risk becoming a lawful target themselves? Are there steps commercial actors could take to distance themselves or segments of their launch vehicles so that they don't become lawful targets?
I don't know that they can, throw up we're not a target, we're just I think this is pretty, I go back to this test as far as whether or not an object by its nature, location, or purpose makes an effective contribution to military action. If you know that your space object is going to be used for, in an armed conflict, I think it's fair game that you could be targeted, and that's a lot of the concern of these entities. The question is like, how close to it kind of gets back to this idea of like DPHing, or direct participation hostilities is a little bit what this is getting at. This two-part test is, or not a little bit, this is what this is getting at. It's like, how much are you participating? So if you're just transporting, but how close to the front lines are you? There could be some arguments, not saying they're good arguments, but like, hey, you're not there yet, you're just, but I think ultimately, just like in World War II, where you had the targeting of, factories and whatnot, it wasn't just when the ammunition or when the stuff gets to the battlefield, things that effectively contribute to a state's military action are targetable, comma, subject to the other provisions of the law of war. So there still have to be, tests. Like, so for example, if a commercial space provider, a space transportation provider was concerned about like, oh, now my launch site may be targetable if my spacecraft is used for transportation during armed conflict, what concerns do I have there? Yeah, it's not like you can say, hey, I'm a private actor, sorry, I'm not targetable. But the adversary for the United States in armed conflict, at least arguably under the law of war, is still bound by notions of proportionality. So, targeting that space object or targeting the space object's infrastructure are still subject to all the other laws of war. But there isn't really like a not it provision that would save a commercial entity if it is engaging in a way that effectively helps the United States in its military action.
Great, thank you, Anna. Quick follow-up question from Aubrey Davis, and this goes to what you had mentioned during your presentation with respect to the issue of lex specialis and what is going to control in an international armed conflict. Aubrey writes, would your analysis, kind of to the previous question, this issue of targeting and problems related to civilian actors potentially being lawful military targets, would that change if perhaps we were in an international armed conflict, but these commercial actors were acting to, for example, rescue someone in outer space, right? Rescue an astronaut or otherwise fulfill some requirement, perhaps under international space law, separate.
Sorry, Jeremy, sorry to interrupt you. You cut out for about last 20 seconds.
Oh, no.
Could you repeat your question?
Yeah, absolutely. Yeah, so the question is, what would your analysis to the previous question change if the commercial actor who was participating to some degree in this international armed conflict was only participating to some degree to achieve an aim of international space law, right? So for example, rescuing an astronaut in space or something that would fall more under this lex specialis of space law rather than the law of armed conflict?
Yeah, I think there might be in the future some sort of carve outs where, like in the same way that, the ICRC is granted special status to, do certain things and is protected and is not targetable. There may be concepts, there may be the possibility for similar provisions so that, a spacecraft conducting a mission that was solely to rescue, assuming they're not already goners, space incredibly hostile environment. If the technology were possible to rescue stranded space passengers, I say space passengers rather than astronauts, because that is more of a legal ambiguity under the law. But also astronauts, there could be room to create that kind of special, almost designation that like, hey, this is a totally humanitarian mission. It does not contribute to the country's warfighting ability, because effectively those players are out of the fight.
Awesome. Well, Anna, thank you so much for being with us this morning. And thank you for closing out our academic year of webinars here. Really, really appreciate your time this morning. And again, thank you for sharing your knowledge of this important space legal topic with us.
I really do thank you, Jeremy. And again, the Law and Technology and Warfare Research Cell for the opportunity to talk with y'all. And if I didn't get to anyone's questions, I'm more than happy to answer them by email.